Mr. Chairman, and we're 4 away from the finish today. Before I begin, I do have a couple of letters I'd like to submit for the record. One from the Speaker of the Idaho House, Scott Bedke, in support of Judge Barrett's nomination, and the other from the National Shooting Sports Foundation, also in support of the nomination, Mr. Chairman.
Without objection.
Thank you. And Judge Barrett, I am going to well, I'll get to some new material, but a lot of what I do at the beginning will be going over things you've already said, and you must think you've said them way too much, had to say them way too many times. I'm going to just be sure that we get some things nailed down once more. Before I do that, though, there's been a lot said today that really needs to be responded to. This won't be a question to you. These first two, I'm just going to quickly respond to a couple of them. The first was one of my colleagues, Senator Whitehouse, spent a very long presentation trying to make the case that there is a lot of dark money out there trying to control the Supreme Court nominations and this whole process and the situation that we face today. I just want to set the record straight. These are actually These are actually some statistics that Senator Cruz quickly went through when he spoke. But yeah, there is dark money in politics, and I think that we should get it out. What this means is that money where you don't know who the real donors are behind the entity that's making the expenditure. Fortunately, we're getting a lot of that out, but there's still a lot there. The impression, though, that was left was that this dark money is all on one side. The reality is, if you look at opensecrets.org, this data is from 2016, but I've seen data even later into 2018. And it's the same kind of statistics, and that is that really the significant majority of the dark money is being spent in favor of the Democratic side rather than the Republican side. Of the top 20 organizations and individuals that they identified who contribute to super PACs, who then utilize the money in the way that was talked about, 14 of them give exclusively to Democrats. Of the top 10 on that list, only 2 give to Republicans. So, and the totals, by the way, were $422 million in this report going to Democrats and $189 million going to Republicans. So yeah, there is money in the system, which we can't identify. A lot of this money, by the way, is going into ads against you, Judge Barrett. But we can't get it all out yet. I think we ought to get it out, but let's not try to create the impression that this is just some one-sided circumstance that's happening in the country. The other thing I want to go over first before I get into my questions is the same thing I went over yesterday because the allegations have been made again and again and again that somehow we are rushing this case and somehow we are violating the history and the precedent of the way the Senate operates and the way the presidency operates when there is a vacancy in an election year. Some people count these things differently. There's a statistic that I will use that will count all vacancies that have happened, whether the vacancy occurred in the election year or whether it just didn't get resolved until the election year. But it doesn't matter whether you just take the ones that arose in the election year or if you take all of them that were resolved in the election year. The precedent is the same. It's overwhelming. In every single case, the sitting president made a nomination. Every case. In those cases in which the Senate was of the same party as the president, I'm going to use the one for all of the nominations that actually were dealt with in an election year. There were 29. 19 of them were when the party was the same as the president. 17 of those 19, the party moved ahead with the president's nomination, and the nomination was confirmed. 10 of those times, it was when the party was not the party of the president. In 9 of those cases, the party that was not the party of the president declined to move forward until the next president was elected. Now, that's the precedent of the Senate. That's what happened in 2016 when the Senate was of a different party than the president, and it's what's happening now when the Senate is the party of the president. And those are the facts, and that's the precedent. In terms of the timing, I went through the timing then as well. I think your hearing started, Judge Barrett, on the 16th day from the day you were nominated. There's a bunch of members of the Supreme Court whose nomination hearings started sooner than that. including Ruth Bader Ginsburg. And so the fact is that normal procedures, appropriate timing, and appropriate policy and precedent is being followed here as we move forward. Now, having made those points once again, I will, like I said, I will get into some new questions for you, but I'm going to go over a lot of things that you've already talked about because I really think it's important that we just make it as clear as possible. You've talked about originalism and textualism. Is there a difference between those two things?
They are the same basic approach, but we use originalism mostly to refer to interpreting the constitutional text, and textualism we use to refer to interpreting statutory text. But they both involve the same principle, which is that one comes to the law and interprets it as it would have been understood by those at the time, if it's either its ratification in the case of the Constitution or its enactment in the case of a statute, and that the law remains the law until it's lawfully changed through democratic processes.
All right, thank you. And I assume you would consider yourself both an originalist and a textualist.
I do, Senator Crapo.
And you've written quite a bit about precedent and stare decisis. Could you just once again tell us what that is? And maybe you could make a distinction between what it means at the appellate level and at the Supreme Court level.
Sure. So there are two kinds of stare decisis. There's horizontal stare decisis, which is, say, the Supreme Court's obligation to follow its own precedent. And then there's vertical stare decisis, which is my obligation right now on the Seventh Circuit to follow Supreme Court precedent because it sits above me in the federal judicial hierarchy. Precedent, for vertical precedent, there's no question. I mean, I can't buck what the Supreme Court does. It sets the precedent and all lower courts must follow it.
Right.
For horizontal precedent, for example, on my own court right now on the Seventh Circuit, the court that renders a precedent does have the ability to reconsider it under certain circumstances. Otherwise, errors don't get fixed, and Plessy versus Ferguson would still be the law of the land.
So, and you will, I'm sure, tell me, what are the rules there when you do horizontal reevaluation?
Sure. So when a court decides whether or not to overrule a precedent, it considers, first of all, is it wrong, and how egregiously wrong is it? That we can see in the Brown versus Board of Education decision how that factor played. You also consider reliance interests because, as I said before, stare decisis is short for stand by the thing decided and don't disturb the calm. So courts don't recklessly get in the business of just stirring up, disrupting people's lives, unless it's the other factors counsel in favor of doing it. You consider whether the law has developed since the precedent in a way that undercuts the foundations of the precedent itself. Same for the facts. You also consider whether the precedent that you set has proved to be workable for the courts below you that must follow it. So in my case on the Seventh Circuit, that would mean the district courts. Have we set out an articulation of the law in a case that lower courts can actually use?
And so, to paraphrase here, if a judge in a horizontal situation, either a Supreme Court justice evaluating Supreme Court precedent or a circuit court judge evaluating the circuit court's precedent, if they felt the precedent was wrong, that's not enough.
That is not enough.
And you have to have then the reliance and the other factors all falling into the right circumstance before a decision to actually overrule or overturn a precedent is made.
That's true, and this might be a good time, Senator Crapo, for me to make one other point about horizontal stare decisis doctrine. Earlier, and I can't remember which interchange it was, someone was pointing out, that I said stare decisis should have weaker effect in constitutional cases. That's actually what the Supreme Court has said. That's a well-established principle of stare decisis doctrine itself. The court has said that it gives super strong effect to precedent in statutory cases because you all can always step in and fix any errors of statutory interpretation the court might make. But the court itself has expressly said that it gives weaker stare decisis effect in constitutional cases because the only way to remedy an error is by constitutional amendment. So I just want to be clear But that is simply a restatement of the court's own doctrine. That wasn't something I invented.
All right, I appreciate that. And you also mentioned earlier that there are some, I think you said 6 super precedents?
Let's see, I can't remember how many are on the list, but as I said, it's in constitutional law scholarship. There are some precedents that scholars have identified as utterly beyond question that no serious person ever calls for their overruling.
Could you, I think Brown versus Board of Education would be one of those?
Marbury versus Madison, which establishes the power of judicial review. Let's see, the cases, probably easier for me to just identify what the precedents stand for. So
Sure.
the power of judicial review, the power of the Supreme Court to review judgments from state courts, the proposition that the 14th Amendment applies only to state action, the incorporation of the Fourth Amendment and by implication the other Bill of Rights, other rights in the Bill of Rights against the states. So they're mostly structural kind of foundational principles, you know, and they're just so settled no one seriously challenges them
All right.
anymore.
Thank you. I appreciate that. I think that's very helpful. And in this hearing, you've been asked about at least 3 very significant Supreme Court precedents, and you've been asked whether you were asked to commit to overturn them, or whether you've even had conversations with the president or his staff about them. One, and I just want you to, again, give your answer on that because I want this to be very clear. Roe v. Wade, have you had any conversations with the president or with the White House staff, White House counsel, anyone, and have you made any commitments about how you would rule on any case dealing with that?
I have not, Senator Crapo.
Thank you. And the same set of questions with regard to Obergefell.
I've had no conversations with anyone in the White House staff about that case, my views of it, how I would rule.
All right. And then finally, the current case, California v. Texas.
No conversations at all.
All right. Thank you. Now, you also earlier testified that there's a difference between judicial decision-making and the process of making a judicial decision versus, say, the process you would make as a professor when writing an article or what have you. Could you just quickly get into that with me?
Sure. So a professor, when writing law review articles or doing academic critique, is kind of at a 10,000-foot level. You know, you're not in the trenches like a judge is because you are not deciding it in the context of a real case with real litigants in front of you, the adversarial process where you have people on either side, where you hear arguments and you consult with your colleagues and you write your opinion. And I think one thing it's worth pointing out about the judicial process is that I have had the experience of changing my mind at various points along the way. I've gone into oral argument more than once thinking, you know, I was going to rule one way, and then oral arguments changed my mind. Or I've gone into conference, and my colleagues have changed my mind. I've even changed my mind, and this is not uncommon on the court, once I started writing an opinion. Judges say, it won't write, you know, which means what you thought was right when you started writing it, you realize actually didn't really work out. So I think that process and the fact that judges keep an open mind all the way through is evidence of how the judicial process really is unique in our system, and it is a different enterprise than academic critique.
Thank you. I've been able to observe that a little bit. I clerked on the Ninth Circuit Court of
That's
Appeals.
right, you told me that.
And so I've been able to observe that exact process in each of those steps that you talked about taking place. And you're right. That's how it happens when it's done properly. Next, I want to go to one more specific kind of process type thing to make sure we all understand it right, and that's the recusal. Interestingly, you've been asked by my colleagues on the other side to assure that you have made no commitments about case law, but that to give a commitment on recusal. You have said that there is a process for recusal as well, and that you would follow that. But could you please lay that out again, once again, for us?
Yes, recusal is a question of law because 28 U.S.C. 455, the recusal statute, actually obligates a judge to recuse in certain cases of either actual bias or apparent bias. And there are Supreme Court precedents interpreting the range of a judge's obligations under that statute. There are also, you know, professional conduct committees to consult, and I think collaboration and consultation, as I've said before, with other justices is the typical practice according to Justice Ginsburg's description of it. So it is a legal question that's governed by statute and precedent, so it's not one that I can make an advance resolution of.
All right, thank you. Now I want to move to, frankly, back to California v. Texas, or Texas, yeah, California v. Texas, and the pre-existing conditions issue that has been raised by a number of my colleagues here. We've heard a lot about the Affordable Care Act yesterday and today. I serve on the Finance Committee as well as the Judiciary Committee, and so this is an issue I really care about a lot. I'm passionate about ensuring that all individuals, especially Idahoans, have affordable, quality health care coverage, and making sure that they have coverage for their pre-existing conditions is especially important. Regardless of what one thinks about the Obamacare legislation. Reasonable people can disagree about the totality of the success of Obamacare, and this is something that I think should be remembered. But many of the policies in Obamacare were policies on which we had agreement between Republicans and Democrats as we moved forward at that time trying to craft a health care law. People may recall this was being negotiated in the Finance Committee for quite a while before President Obama pulled it back and then brought his own statute out. And one of the things that we had agreement on was protecting pre-existing conditions back then. There was no fight over that. And in fact, I think every single U.S. senator wants to protect access to coverage for patients with pre-existing conditions, Republicans and Democrats. So here we are now talking about the Obamacare legislation that was pushed through the Senate when there was a Senate and a president of the same party and the ability to avoid a filibuster. And we're now looking at legislation challenging one part of that. Again, you've talked about this, but I'd like you just to set up this next question. There's a difference between NFIB versus Sebelius, the case which you have made some commentary on, and Texas v. California. Could you tell me the difference?
Yes, NFIB versus Sebelius involved whether the mandate violated it was framed initially as a case about whether the mandate violated the Commerce Clause. And the majority in that case, as you know, I've discussed in earlier interchanges, interpreted the mandate provision to be a tax rather than a penalty. And Chief Justice Roberts said that he thought it was justified as an exercise of Congress's taxing power, but would have been invalid under the Commerce Clause. Now, the new case that the Supreme Court is poised to hear involves a different question. If the mandate, which has now been zeroed out, the initial question, it does resemble NFIB versus Sebelius, because the initial question is something a tax if it's $0? So is it still a tax? And if it's not a tax, can it be justified under Congress's taxing power? But severability, even assuming that it is no longer a tax because it's zeroed out, the next question is, if that provision is unconstitutional, does just that provision become inactive, so to speak, or does the whole statute fall? And that is the question of severability. So in some respect, whether one thought that the mandate was unconstitutional or not, the act would have to be found, that would have to be unseverable.
And you may not know the answer to this, but I believe that in the last session of the Supreme Court, 7 members of the court said that there's a very strong presumption in favor of severability rather than knocking down an entire statute.
That is true. It's an established doctrine, and it was reiterated even last term.
So did you participate in a moot court case on this last month or in the last near future?
I did. Can
you tell us what a moot court case
Sure.
is?
So William & Mary Law School has every year what it calls its Supreme Court preview, and it includes a moot court case. There's a long tradition of moot court exercises at law schools. Sometimes they're called mock trials. Sometimes they're called moot courts. That's when they're appellate. And it's a chance to educate the community around the law school, the students, or in the case of this William & Mary program, it also draws in people from around Williamsburg so that they can see how the judicial process works.
And judges often participate in moot courts, right?
Judges often participate in moot courts, and in this particular one, there were maybe comprising the panel, the conference involved several other events, but this moot court involved a panel. It was supposed to be a mock argument for this case, and there were about 4 judges, a couple law professors, and some journalists who were on the panel with advocates fleshing out the case, so that we did it by Zoom because of the pandemic, but so that students could see how the process might look.
And so what did the moot court decide?
Well, I do want to preface this, Senator Crapo, by saying it was an educational exercise.
I understand.
So it was made very clear to the audience, both at the outset and then in the deliberation room and then outside, that this was not designed to reflect the actual views of any of the participants, and nor could it, because, this was show up, you're not reading the briefs, diving deep down, and, a lot of times people change their votes in the deliberation room just for the sake of mixing it up and making it interesting.
I understand, and I appreciate you making that clear.
I just want to make clear the context. The vote was in the panel, the majority said that the mandate was now a penalty and was unconstitutional but severable. I think there was also a group in a minority who said there was no standing. To be honest, now I can't remember. Maybe there was, I could be wrong about this, and I feel like there was maybe another minority that said it wasn't unconstitutional.
And how did you vote?
I voted to say that it was unconstitutional but severable.
All right, so you voted in favor. The one clue we might have as to your thoughts on the issue, even though this was just an exercise and you didn't have the whole case presented, and I understand that, but I'll just say to the viewers, the one clue we have is your ruling in this moot court case. And I think that's kind of an answer, frankly, to a lot of those who are raising this specter that you're going to try to take the whole Affordable Care Act away from everyone because of this very narrow case that is in front of the Supreme Court.
Although I do want to be very clear, Senator Crapo, for the record, that it wasn't designed to reflect my actual view. So to the extent that people think I might have been signaling to the president or anyone else what my views on the Affordable Care Act are, they couldn't have taken any signal from that, certainly.
I understand.
But I wasn't trying to signal anything because it was a mock exercise.
It was a mock case. It was a moot court. I understand that very much. Let me just go into a couple of other issues here. In fact, I can hit them very fast. Senator Ernst mentioned the Orchard Hill versus Army Corps of Engineers case on the waters of the United States. That is a big deal in Idaho and, frankly, in most of the western United States, in fact, most of the entire United States. And I appreciated your ruling, and I'm just going to tell you, I'm not going to ask you a question about it. I appreciated your ruling. I am going to ask you a question about the Chevron Doctrine. And this is one of those you may not be able to respond to, but would you tell me what the Chevron Doctrine is?
Sure. So I got into this a little bit with Senator Ernst. The Chevron Doctrine is the doctrine that when a statute is clear, then that's end of case. But if Congress passes a statute that's giving an agency authority, or that's describing the boundaries of an agency's authority, and there's ambiguity in that statute, then the court will treat that ambiguity as a delegation to the statute, a delegation to the agency to fill in the details.
Yeah, and I'll just tell you, I disagree with that doctrine. I think that the courts ought to have the ability to interpret the statute, and if it's ambiguous, they should interpret it as best they can, and that the interpreter in our system should not be the agency that is enforcing the statute. I think the courts should oversee this. Now, that's just my opinion. So the question that you probably can't answer is, what's your opinion?
You're right, I can't answer, Senator Crapo.
Okay. Well, thank you very much. I just had another couple of quick questions. I was going to go into the Heller case. Well, I will ask you. Tell me, what do you believe the basic ruling of Heller is?
The basic ruling of Heller is that the Second Amendment protects an individual right to bear arms for self-defense.
So if I were to characterize it as the Heller case reaffirmed that the right to bear arms is one of the rights guaranteed in the Bill of Rights to individuals.
That is what Heller held.
That's what Heller held. Okay. You know, I do have a number of additional questions, which were just kind of softballs. But
I like softballs. I'm fine with that.
maybe you deserve softballs right now, but I think instead, I'll give you the break. And you can
like
have,
that too,
you
Senator
can have the
Crapo.
last 5 minutes of my time, or you'll get done 5 minutes sooner. Thank you very much for being willing to do this. You are an outstanding nominee, and I am very glad to be able to support you.
Thank you, Senator Crapo.